Morgan, if everybody's here, we can get started.
We are still waiting for the plaintiff's attorney.
Oh, okay. All righty. I'll sign off then for another few minutes.
Good morning, Judge Gleicher. It looks like we have the attorneys as well as the court reporter ready whenever you are.
Great, I'm ready.
Okay, I'll bring.
All right. Good morning, Council. I guess Ms. Roberts is going to stay just a blank screen. Is that right, Ms. Roberts? That's fine with me. I just want to make sure that's your preference, or you don't even have to answer if that's good. She's muted. That's our court reporter. Let me call the case, which is Hassan Ahmad versus the University of Michigan. Court of Claims, docket number 17-170-MZ. I scheduled this hearing today on the university's motion to stay the effect of an order I entered on July 7th, requiring the university to produce a Vaughan index of what I understand, but can be corrected, about our 10 boxes of paper, materials, other things given to the university by Mr. Tanton, Dr. Tanton. And just so that we get to the point here more quickly, I'm going to let you both speak in a second, but I do want to let you know my concern that I hope you'll address. Mr. Schwartz, you are Mr. Schwartz, right? I see that. That's what your Zoom handle says, so I'll presume that's correct.
That's me. Yep.
Okay.
I need to see an ID from that gentleman on the screen.
Right. Yeah, I guess that is an issue with Zoom, right? Anybody can just show up. But anyway, my concern, Mr. Schwartz, and is that you've also filed a motion for summary disposition, and you've raised, by my count, 4 legal arguments. Probably 3 of them can be decided without reference to the substance of the documents, but one, the privacy exemption claim, I don't know how I could possibly decide whether or not the privacy exemption applies to documents about which I have no idea in terms of what they say. Or it could be a grocery shopping list in there, or it could be, a love letter from Dr. Tanton to his wife. I mean, I don't know what it is, so I don't know how I could ever assess whether that exception applies. But just keep that out there in the background, and I'd like you both to address the issue in any way that you feel is appropriate.
Thank you, Your Honor. And I will. I assume you want me to go first, since it's
Please,
my motion.
yes. If you're the moving party, so yes.
Normally I'd stand up and move to the podium, but that wouldn't work here.
Right.
We, as set forth in our motion, we believe there's a
Can
few
we start
reasons.
with introductions, please?
Oh,
I
I'm
can
sorry.
have that on the record.
Apologize.
Not usually trying to start the court. Okay.
Sure. This is Brian Schwartz appearing on behalf of defendant, the University of Michigan.
I'll just jump in right now. This is Attorney Philip Ellison appearing on behalf of the plaintiff in this matter.
Thank you, Your Honor. As set forth in our motion, we believe there are several reasons why the stay should be granted, and I think you hit the nail on the head on that. The first reason, the various reasons why when federal courts have allowed a Vaughan index, I don't think exist here. The reasons why, this is somewhat of an unusual FOIA case where it's potentially the whole cache of documents could be exempt by several of these arguments. As you mentioned, they don't require a document by document analysis. I think that applies to all of the arguments and the exemptions we raised, particularly the Library Privacy Act and the Community Foundation Act. It doesn't require you to look at what's in each document. I also think the privacy argument also allows the court to, at a first step, take a look, and if the gift agreement applies to the whole cache of documents where Dr. Tanton took the view that he had a personal privacy stake in these documents, there's no need to look at those documents. Now, if the court concludes otherwise on that, then it's at a second step, it might have to do a document by document analysis. But as Justice,
let me interrupt you. The whole purpose of a Vaughan index is so the court doesn't have to do a document by document analysis. I mean, we basically, as I understand Vaughan indices, judges allow counsel to do that as officers of the court, making representations that are accurate and truthful about what the documents are to save the judge's time. I mean, I had to do that in a case in the last couple months, and it wasn't so easy. So, that's not something that judges need to take time to do.
Thank you, Your Honor. I wasn't suggesting that you would need to go document by document, but I was suggesting the parties, the council, would not need to make that document by document assessment if the gift agreement as a whole,
Right.
if the
Okay.
court concludes that the personal privacy exemption, by just looking at the gift agreement as a whole, it acts to exempt that category of documents. If that does not work, and if all the other arguments don't work, then we're at the stage that we might have no other choice but to go into the documents. But to unring that bell, by going in there when Dr. Tanton expressed his intent that these should be closed, closed to access, is something that just can't be undone. And if there's these threshold arguments that could be addressed, I think that's the most expeditious way to resolve that.
Okay, Mr. Ellison?
Yeah, good morning, Your Honor. So I can appreciate the position Mr. Schwartz is in, but at the same time, I have to kind of belt and suspender myself here in these kinds of cases. Judge, I'm certain that there's no way I could not have been before you at the Court of Appeals on a FOIA case. I do a lot of these kinds of appeals with FOIA cases regularly before the courts. My concern is right now, the argument that you're being told is you can decide these solely based on the what they call the donor agreement itself, which has been the subject of my screaming going up to the Court of Appeals as well as the Supreme Court, that we've never got to see this particular document, and now you're going to be able to see this particular document. If it's the university's position that their sole basis for invoking the privacy exemption, or any exemption for that matter, is solely because of the Tanton gift agreement, I would agree that a Vaughn index is not necessary. The concern that I have is that the university has been playing bouncing ball with exceptions. And my concern is that if you say, okay, if I was to voluntarily agree, you don't need to produce a Vaughn index, and you reject it, I think I'm going to make a very strong argument to you in response as to why none of those 4 exemptions apply, because the university has the burden of proving those exemptions. I don't have the burden of proving them at all.
Okay, let me stop you for a second. Let me stop you because and Mr. Schwartz, tell me if this is right, because when I read your 2 things, first, I'll ask Mr. Ellison. You haven't yet filed a response to their motion for summary disposition, correct? It's not due yet, so I'm not criticizing. And if you need more time, I hope I'll give it to you. So
we're going to raise that today, I've already reached out to Brian because I just got back from Cincinnati at the 6th Circuit late last night. So as you can see, I'm still living at home. So
I'm always at home.
Yeah.
I'm at home too, even though that looks like not home, but I'm at home.
Good. All right. So I will need some more time, but I guess the point I wanted to get across to you, not to co-opt you here, Judge, is that if the university is making the representation that they're not going to be looking to the contents of those documents to assert an exemption, then I don't need a Vaughn index. My concern is that if they all of a sudden we get through these 4, which I'm again, as an advocate, I'm going to say to you, I don't think they're going to be able to meet their burden, which is their burden on these 4 exemptions. My concern is then they're going to say, oh, well, now we want to start looking at the content of the documents to raise yet further new exemptions that apply. And then we would need a Vaughn index.
Okay, so here's what I am thinking about proposing, but you tell me and I'm going to summarize where I think we are on the motion for summary disposition. And you tell me what objections you have, because my next step is if the 2 of you can agree, I'm going to ask you to prepare an order to this effect. So, Mr. Schwartz, in reading through your motion for summary disposition, it appears to me that you've raised 4 issues, which I'll summarize momentarily. 4 reasons that summary disposition should be granted in your favor. Number 1 is that the gift agreement precludes access, and you've mentioned that today. Number 2, you've invoked exemption A of the FOIA, that the documents include information of a personal nature. I'm going to skip over that one for the moment. I'm not going to say any more about it, at least at this point, other than to say you've invoked a FOIA exemption. Number 3, you've relied on the Michigan Community Foundation Act. And number 4, you've relied on, alternatively, the Library Privacy Act. Have I summarized your arguments, or did I miss any?
No, that is, and that those are in about as quickly as you could summarize them. I think that's accurate.
Okay. What I'm going to propose is that you two agree, first of all, on an extension for Mr. Ellison, and just Mr. Schwartz, just so that you know, I sign orders every Tuesday granting people extensions in the Court of Appeals. I've never denied an extension in 12 years. I'm not going to deny extensions in the Court of Claims. That goes for everybody. I don't know if you know this, but I'm married to an appellate lawyer who would die if he didn't get extension. So if he ever heard that I denied an extension, there would be a complaint for divorce on my desk. So,
Well, Judge, I think you have two lawyers in front of you who would probably die without extensions too. So,
right. Okay. Now, just to let you know, do not fight about extensions. You can fight about a lot of things, because I'll resolve it in the favor. I'll give double time to whoever wants it if you're fighting.
Knowing Brian, how Brian and I've worked together, that's not a concern in this case whatsoever.
Okay.
So,
We've granted each other extensions about as fast as email could move across the screen.
I'm
so
very happy to hear it. Okay, so what I'm thinking is agree on an extension, and agree, Mr. Schwartz, if you would, that you will withdraw for temporarily, or whatever language you want to put in there, the argument involving the exemption A, and let the court decide the other three arguments without the Vaughn index. And then if the case survives summary disposition, we can readdress the Vaughn index and what we're going to do about that in terms of exemption A. Does that make any sense?
It does to some extent, Your Honor. One of the portion of the argument where the gift agreement precludes access is it's kind of tied in with A, so it's hard to completely decouple it from the privacy argument. But I can make it clear that we're not, as part of, we're arguing at the whole cache. We're not arguing in this motion that that there's home phone numbers or medical records that he may have donated. That, so it doesn't require anybody to look at that sort of issue. And that's the purpose of the motion here today, is like, why should anybody wade into this if a threshold issue resolves it?
Okay, and I'm willing to, obviously I read your brief in support of summary disposition. I can't say I read it as carefully as I will read it when I sit down with Mr. Ellison's brief. I mean, I'm going to reread it then and pay much more attention to it. I did get the impression that the gift agreement argument could potentially be decided without reference to the documents themselves, but that's a bridge. I guess my preference would be leave it in there, leave it in the mix for now. And if the court finds that, if I find that it can't extricate the substance of that argument from the substance of the papers, I can let you know that. But I'd rather, in terms of judicial efficiency, try to get as much done in one sitting and in one order and opinion as possible. Mr. Ellison.
I guess, Judge, if we could have a stipulation from the university that the sole basis of their 13-1A, the privacy exemption, is in fact the Tantan agreement itself for purposes of this motion, I'm perfectly all right with that. My concern is with the Vaughn index, and not that I'm trying to poke Brian with a stick or anything, but my concern is that I don't want to be left that at the end of discovery not having obtained all that unnecessary information, and they assert a new exemption in specific documents or specific information contained within the document. So I guess what I would suggest is I would be, and this is going to sound odd, I would rather the exemption stay in and brief all of those issues in one shot, as opposed, so long as the university is stipulating that the premise behind the 13-1A exception, the privacy exemption, is in fact the Tantan agreement itself.
But,
if that's the case, I'm okay with that.
Hold on, you're the one who argued that, if I understood your response to the motion that's pending in front of the court now, you're the one who argued that it was impossible to determine whether the privacy exemption applied without some understanding of what's in the documents. Did I mischaracterize your argument?
Well, I would say no. Let me asterisk as a lawyer. We have to split the hairs properly, right? If the university is saying that the sole basis for invoking the privacy exemption, meaning it's not what's in the document, but rather just the Tanton agreement itself, meaning the actual agreement itself, then we're not looking to what's in the documents, because I as a plaintiff's lawyer can't look at the documents because the university has them, and the university's we either got to do a Vaughn, and usually what happens, we either do a Vaughn index or we do
Right. Okay. All right. Let me stop you, because I'm not going to force the university to do that. I'm just going to tell you right now that I think the university has an argument, and whether it's viable or not, I don't know, that the donor agreement precludes any look into these documents, period. I think that the university potentially, and maybe Mr. Schwartz will correct me, potentially has a second argument that even if the donor agreement doesn't preclude looking at the documents themselves may contain material that's exempt from disclosure under 13(1)(a). Is that right? Am I correct, Mr. Schwartz, or not? Correct me.
That is correct. It's like 2 levels of that
Right.
argument.
And I'm not going to preclude, I see no reason to preclude them from making that argument. I mean, they have a right to make that argument.
That's the point I'm getting at, Judge. If in fact the basis of their motion is number one, the first theory you laid out, then there's no need. I agree. There's no need for a Vaughn index.
Okay. All right.
It's as to the second argument is where the Vaughn index becomes critical.
All right. So let's do this. I would like the two of you to try to draft an order. If you can't, you can't, and I'll draft it. But I like it better since I do my own typing if you do it. Setting a date for Mr. Ellison's response. Giving me some hint as to when you would like argument, or if you want argument. You can have it if you want it. So just you could say argument to be scheduled by the court. And agreeing that the court will first decide 3 of the what we'll call 4 legal arguments made by the defendant in the summary disposition, and that we will revisit the Vaughn index if the case survives summary disposition. You can use whatever language you two could want to work out. Is that something you can both live with?
Sure.
Because that, if you can't, I'm going to enter that order in my language, but I'd rather you two work it out in a way that you feel comfortable with.
Just so I understand, you want to basically punt on the privacy exemption for now, is what you're asking.
I don't know if I'd use the word punt. I'd say table. How about table?
Okay, table. Okay. That would be acceptable to me because the reason being is that we don't need to see what's in the documents to be able to assert those arguments going forward for us. So I'm perfectly all right with that. The only thing I will say is, Brian, just know that as you can see, I'm still at home, and they're doing construction at my office today too. So it's a double whammy. So, Judge, we will get you an order. I'm certain Brian and I can work out an order.
Brian has a huge law firm. His people can do it, I'm sure.
So just know, Judge, it may take me to Monday or Tuesday to get
that's
something.
Fine.
Okay. All right.
Fine.
All right.
Okay. Is this helpful at all? I mean, it's been very helpful to me. I hope it's been somewhat helpful to the two of you.
Yeah, I think it has been, Your Honor.
Okay.
You saved me writing 4 pages of trying to structure this the right way. So
right. I mean,
that.
And it saves me time too. I mean, I want to be responsive to the best of my ability. Although I have to tell you, just as an aside, I'm finding the Court of Claims on top of the Court of Appeals somewhat heavy lifting. But it is what it is. I said I'd do it, so here we are. But anyway,
you want to get Judge Kelly back in the
Judge Kelly doesn't want to come back.
I discovered that we had him on the tax equity cases that you now have inherited from him that my office is prosecuting. So
he's very happy that he's not in this Zoom right now. But anyway, I
our level best to make this fun for you. I promise. I can.
Right now, this is one of the more.
Mr. Judge, you all are kind of talking on top of each other, and so
I'm
having difficulty getting this down. It needs
Okay.
one person at a time, please.
We all apologize, Ms. Roberts. Okay, well, with that, we can wrap it up. Let me know if there's anything else I can do to help this case move along, but it sounds like with this order, we'll get things more efficiently in line for a decision. And then we can, if it survives, we can go to step 2.
Very good.
Okay,
Thank you.
thank
Any
you.
orders at this time, Judge?
Pardon me?
Does anybody need to order the transcript at this time?
No.
No,
Okay, thank you.
Okay, thanks, guys. I'll look for the order in a week or 2.
thanks, Your Honor.
Thank you.